Good evening. Good evening. Good evening, everyone. Can you hear me? Is this clear enough? Testing. That's much better, Chad. Good evening, everyone. We apologize for the late start. However, we are going to begin right now with a word of prayer. Can we stand as we pray the Our Father? Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. Thank you very much. Good evening and a very pleasant welcome to another consultation on electoral reform in the Commonwealth of Dominica. This evening, we are at the Northeast Comprehensive School in Wesley to hear from the people of the Northeast on the Sir Dennis Byron Electoral Reform Report, which was presented to the government of Dominica in June of 2023, after a comprehensive review of our country's electoral processes. At this time, I would like to welcome among us the honorable members of Cabinet who are present, the parliamentary representatives for the Wesley constituency and the Paybush constituency, and we have with us the parliamentary representative and Minister for Education from the Castle Bruce constituency, and Honorable Dr. Vince Henderson as well, who has joined us. I would also like to recognize in our midst the Honorable Attorney General, Honorable Levi Peter. We have with us this evening the former Prime Minister, Ellison James. We are very happy that you've joined us, and the former Leader of the Opposition, Mr. Lennox Linton. We welcome you this evening. We would also like to welcome our observers who have been with us for the last 2 weeks, Justice Raphael Masaga of the Commonwealth Secretariat, Ms. Melin Glynn of the OAS, and Mr. Dwight Lay of the OECS. Dr. Kenneth Daru, Special Envoy in the Office of the Prime Minister with responsibility for electoral modernization, permanent secretaries, and other senior government officials. We have with us this evening chairpersons and members of various village councils in the Northeast, members of the media, other invited guests, and those of you who for the last 2 weeks have been following and listening to us live on various social media and media platforms. Over the last 2 weeks, the public consultations have been held on electoral reform and more specifically on the recommendations of the Sir Dennis Byron report. The Phase 1 report, which focuses on what we have been referring to as the cleansing of the voters list, includes 2 new proposed bills, the Registration of Electors Bill and the Registration of Electors Regulations, and 2 pieces of legislation that would be. And then we have the Phase 2 report, which is concerned with matters of access to the media, campaign financing, and matters related to the Electoral Commission. It also proposes 4 pieces of draft legislation: the House of Assembly Elections Bill, the House of Assembly Elections Regulations, House of Assembly Election Petition Rules, and the Electoral Commission Bill of 2023. Over the last 2 weeks, we've consulted with a number of stakeholders, including the legal fraternity, members of political parties, groups and associations, and this week we are meeting at the community level to hear from you, from you, the voter. We would like to hear your thoughts on electoral reform, but more specifically, we would like to hear your thoughts on the recommendations that have been put forward in the Sir Dennis Byron report. The Attorney General, Honorable Levi Peter, will provide for us an overview of the Sir Dennis Byron report after which we'll open the floor for your comments, your feedback, and your recommendations as it relates to electoral reform in Dominica. So at this time, I would like to welcome Honorable Levi Peter, who will present to us a summary of the report. Let's welcome Honorable Peter.
Thank you, Madam Chairperson. Cabinet colleagues, members of the Observer Group, Justice Masaga, Commonwealth Secretariat, Ms. Meline Glynn from the Organization of American States, and Mr. Dwight Lay from the Organization of Eastern Caribbean States, OECS, all village council chairs who are present, all other invited guests, the former Prime Minister, Mr. Edison James, the former Leader of the Opposition, Mr. Linton. Welcome one and all, and I trust we can have a fruitful conversation this evening. As you have heard, the report from Sir Dennis Byron consists of two phases. Phase one focuses on the cleansing of the voters list, and as you heard, is underpinned by the Regulation of Electors Act 2023 and the Registration of Electors Regulations 2023. Those are two pieces of draft legislation that Sir Dennis proposes should be adopted and enacted to support the proposals or recommendations that he has advanced. There are a number of recommendations, and the main parts of the report, the Phase 1 report, I suggest are parts 3 and parts 5. And in particular, in those parts, these heads are dealt with: identification cards, registration for electors, residency, and confirmation. Residency is a significant issue, and it has obviously been discussed at some length. It may arise tonight. Perhaps the main point to recognize in relation to residency is that the Constitution provides at Section 33, subsection 2, at A, it provides that any Commonwealth citizen who is 18 years of age or above and satisfies the residence or domicile criteria and is not disqualified from being registered is entitled to vote. I'm not reading from the Constitution. Those who have a copy of the Constitution can see the precise words, but I believe that that is a reasonably accurate summation of what is in Section 33, subsection 2A. And I would suggest that an important factor in the residency debate and discussion is to note that at 33, 2A, it is dealing with the situation that's required for a person to be registered. That is, a person who is not yet registered and wishes to be registered would need to satisfy those criteria. Commonwealth citizen, 18 or above, and satisfies whatever the criteria are in the relevant legislation. And interestingly, is not disqualified for failing to satisfy those criteria for the purpose of registration. I think the actual words in this subsection are to be registered. Now, interestingly, at B, that is 33 to B, It's dealing with a person who is already registered, and what it provides is that such a person is entitled to vote unless they are disqualified, again, for the same registration elements. That is significant, I suggest, because it is establishing the right of every citizen to vote. And that right could be resulting from their initial registration as a result of residence or domicile. Two different things, but so two means of achieving that end. And in Section 7 of the existing Constitution provides that a person who is on the register is entitled to remain on the register even if he or she travels out of Dominica and remains out of Dominica for a period less than 5 years. That has been interpreted as meaning if somebody is living out of Dominica and within a 5-year period they return to Dominica, that they are entitled to vote. I'm obviously simplifying the situation because there are references to the relevant period, which is generally election, date of election and so forth. But effectively, within a 5-year period, you return to Dominica once or more, but at least once, you're entitled to continue to remain on the register. Much of the debate is whether that should, well, there are some who say that that should not be the case at all, that once somebody is not resident in Dominica, they shouldn't be allowed to vote. So that's one view. There's another view which says that the fact that a person has now provided, once they return to Dominica, at least once during the 5-year period, they are entitled to vote. There's a second group of people that think that's fine and that should remain. And there's another group of people who believe that that 5-year rule should not exist at all, and that anybody who is on the register, once registered, should remain on the register, and their name should stay there, and should only be removed if and when they die, or if they request for their name to be removed. So those are 3 scenarios that that Dominica will have to consider as part of this consultation to decide which of those options that they feel should be adopted and apply to our electoral framework. In the report that Sir Dennis provided, he recommended that there should be a 5-year period, but rather than returning once, a person should have to return and spend at least 90 days in Dominica during that 5-year period. He provided an alternative, which he said, for example, if you feel 90 days is too demanding, then I suggest 50 days as an alternative. Again, some people agree, some disagree. The same 3 options would apply, and you will indicate where your view is on that. That is provided for at Clause 26.1 of the Proposed Registration of Electors Act 2023. Now, the other matter is the issue of identification cards. You've heard the discussion. We've been discussing identification cards for several years now. You know, in terms of what the card will be called, some people argue it should be called a voter identification card. Some argue it should be called a national identification card. So Dennis, in his report, the final report, proposed that it should be called a national identification card. I said in at a previous consultation that from a personal perspective, and if I understand what the card is for, my understanding is that the card would be used for the purpose of ensuring that anybody who voted in an election was the person who was lawfully entitled to vote. So if Levi Peter appeared at a polling station and there was a question of being sure that the person who presented themselves was indeed Levi Peter, that Levi Peter would be required to provide a card with certain information which related to him as a particular individual, and satisfied the officials at the polling booth that indeed is Levi Peter standing before them. So from that perspective, whether you call it a voter identification card, a national identification card, a parish identification card, or a Christmas card, I suggest it doesn't make a great deal of difference. What I suggest is of greater significance is the information that is required to be on that card to ensure that it is the person in question. You may take a different view, and if you do, you're welcome to it, but I just thought I would share that for purposes of discussion. So then it's also recommended in his report in relation to the issue of the information that should be provided by way of helping to cleanse the list and ensure that individuals are who they say they are. He suggested, or proposed, I should say, that certain public officers be required to provide information to the electoral office. One category is the permanent secretary of the Ministry for Foreign Affairs, who Sir Dennis proposed that should not later than the 30th of May in every year should submit to the Chief Registering Officer a report containing, as at that date, the name of every person who is in the service overseas, that's serving the government overseas, diplomats and so forth, the names of all registered electors who are in that category, and those people who, having previously been in that category, were no longer in that category. A second source of information that Sir Dennis recommends is the chairman of the Mental Health Review Board, who Sir Dennis recommends should every quarter provide information to the Chief Registering Officer, namely the name, street address, date of birth, and occupation of every person who has been certified during that period as having a mental disorder as defined under the Mental Health Act. The Mental Health Act defines mental disorder at Section 2 as mental illness or mental deficiency, however caused or manifested. You may want to consider and indicate as part of this confirmation process whether that is information that you think is appropriately or should appropriately be provided to the Chief Registering Officer, whether that is sufficient if you think it is, or whether more information should be provided, and so forth. The final category of information that Sir Dennis, or the final head that Sir Dennis proposed in relation to cleansing of the list under phase 1 is confirmation. And what he proposes is that within 30 days of the enactment of the Registration of Electors Act, the Electoral Commission must declare a confirmation period, and that period must be of a minimum of 6 months or a maximum of 9 months duration. So Dennis proposed that the Commission would be empowered to declare the period and facilitate the confirmation the confirmation of registration of persons, and that relates to people who are already on the list. So it doesn't apply to people who want to register and are not yet registered. They would have to go through the normal registration process, which is provided for and is the same as it currently is. But this would apply to those people who are on the list. So Dennis also proposes that consideration may be given to confirming people outside of Dominica, but he has put that in square brackets at clause 52 of the Registration of Electors Act to 2023, and he has invited or saying that the consultation and Dominica will decide whether it feels that it is appropriate for people to be confirmed outside of Dominica or not. So that's another issue for the discussion. Now, that concludes phase one. Phase two of Sir Dennis's report really is focused on things which are new to our electoral landscape. Access to the media and campaign financing, he recommends, and they're provided for in the House of Assembly Elections Act 2023, the draft that Sir Dennis proposes. The access to the media, as it suggests, is a recommendation that political parties and candidates for political office should be allowed to have equal time to spread their word or their message in the media. He confines that to state media. Some people believe it should be extended to include private media, but also some people indicate that there are additional difficulties with including private media. That obviously is something for discussion and final determination. Second matter is the use of electronic voting systems. Sir Dennis proposes that the electoral process should be conducted by way of electronic systems, but he recognizes that that is not appropriate for the immediate circumstance, but he makes that recommendation and recommends that the Electoral Commission and the state work towards that becoming a reality. Campaign financing, the third element Sir Dennis refers to, as the name suggests, that deals with his recommendations that there should be limits on the funding that is raised and that is expended during the course and for the purposes of an election campaign. He sets out a number of conditions that he recommends should apply to supplement or to implement his campaign financing recommendations. Access to the media is dealt with at Clause 50, which is found in Part 3 of the House of Assembly Elections Act 2023. Voting systems is found at Part 4 and dealt with at Clause 51 to 53. Campaign financing is dealt with at Part 5, Clause 54 to 75. And the offenses that he recommends should apply to this area, and the penalties are found throughout those same provisions and range from $6,000 or 12 months imprisonment to $10,000 or 12 months imprisonment. Finally, Sir Dennis recommends that there should be changes to the Electoral Commission. He suggests that there should be additional numbers. He suggests or recommends that there should be an enactment of an Electoral Commission Act 2023, which would be new. We don't have one at the moment. Electoral Commission is dealt with in the Constitution and in other statutory provisions. So Dennis recommends that the Commission should have more financial autonomy, more autonomy in its staffing appointments, and that all members of the Commission, all members of committees that are appointed by the Commission, or the Chief Elections Officer, all officials who function within the electoral office should also be required to declare any private interest that they may have in relation to matters which may come up before the Commission. For those who are more interested and wish to take note, the responsibilities of the Electoral Commission are set out at Section 38 and 51 of the Constitution. Section 38 states that and I'm just going to paraphrase, the Commission is responsible for A, registration of voters for the purpose of electing representatives, and B, the conduct of election, the election of representatives and senators. So those are the two areas that Section 38 of the Constitution provides that the Electoral Commission is responsible for. Section 51 of the Constitution provides that every proposed bill or regulation, so for example, the legislation that Sir Dennis is recommending, Section 51 proposes that this must, before it goes to Parliament, must go to the Electoral Commission so that they can review and comment upon those drafts. It is in fact, Section 51 provides that it goes both to the Commission and the Chief Elections Officer. And importantly, what Section 51 says is that it must go to them so that they have sufficient opportunity to make comments thereon. That is the requirement insofar as the legislation that we are considering is concerned. I think I will stop there and simply say that the matters to be discussed are entirely up to you. I have highlighted a few. You may have identified others in your reading of the report and in your reading of the draft legislation provided with the report. And I do encourage you to raise those matters tonight. Thank you very much.
Thank you very much, AG, for this summary. At this point in time, we open the floor for your comments and feedback on various aspects of the report. Just to recap, there are some clear issues that were presented to us in the Sir Dennis Byron report, which the AG has summarized. So these issues include identification of voters. Should we have identification cards for voting? There has been much discussion on whether it should be a voter ID, as the AG said, or a national ID card. So we'd like to hear your views on this matter this evening. And with regard to the scenarios described by the Attorney General, should anyone be removed from the list? If so, how should this be dealt with? Should one be in Dominica for 50 days or 90 days during a 5-year period or 10-year period as described in the report? Or should there be no restriction at all? Should there be restrictions on political parties in terms of campaign financing? These are just a few of the burning issues that may be on your mind. However, please feel free to share any other thoughts that you may have on the Sir Dennis Byron report. I would like to remind us all that we are here for consultation. We are here to hear your views. Our views may not be the same. We may have differing views, but I do ask that as we have asked for all of the consultations, that we respect each other's views, that we allow each other to express our opinions on these matters, and that we have a very honest and frank conversation. We have, just raise your hand and you may speak from the podium, or a mic can be brought to you, so you will let us know. Okay, so the suggestion is that because of the lighting, we would recommend that if you'd like to speak, that we use the podium. Okay, Mr. Linton would like to speak first. And then we have, just let me see your hand so I can acknowledge you right after. Okay, then we have a gentleman to the back, and okay.
Madam Chair, thank you. The new arrangements for a consultation in the Marigot community was made known to me when I arrived here this afternoon, because I thought that this was the venue for the consultation for the Northeast, which included Marigot. And so I was already here. And for that reason, I'm going to ask the residents from Benz to Wesley to be patient with me, because I realize I'm on your time this evening. And I want to say a word of welcome to the members of Cabinet, members of the 11th Parliament who are here with us this evening. Madam Chair, Mr. AG, I want to say a special word of welcome to the observers, M. Raphael Masaga from the Commonwealth Secretariat, Ms. Melene Green from the OAS, and Mr. Dwight Lay from the OECS, and Mr. Envoy on Electoral Reform, a very special good evening to you, sir. Mr. Former Prime Minister Edison James, good evening, sir. participants in tonight's consultation. I want to begin with an observation on campaign financing, which is provided for in the in the provisions for the new House of Assembly Elections Act. And I do so because of comments I've heard at these consultations, as they have progressed in recent weeks, about campaign financing regulation, meaning the Treasury is going to have to provide money for political parties to campaign. I want to note that nowhere in the report of the consultant, Sir Dennis Byron, or in the actual proposals for revising the legislation, the House of Assembly Elections Act, is anything of that nature mentioned. And to make the observation that in this democracy, I believe we are committed, all of us, to a democracy where everyone has an equal voice, and that those to whom the people periodically transfer power to govern are held accountable to the needs of the people. The observation must be made that competition for political power is a key feature of life in countries run by government of the people, by the people, for the people. Political parties must raise money to fund the operations that allow them to exist and the election campaigns that present their national development plans and programs for the consideration of the people. Parties here in Dominica normally raise money from members, supporters, other individuals, or corporate donors. However, with private funding, there is the risk of influence from contributors who want to use the operations of government for private gain. Campaign finance regulation is necessary because money cannot be allowed to have controlling influence in our political system such that elections can be determined and or purchased by big money interest or criminal enterprises. So, campaign finance reform is about solutions to the critical money in politics issues that are negatively affecting elections. We have a responsibility to reform and to improve our campaign finance system with election laws that amplify the voice and impact of the people as the legitimate source of authority of government, remove the unfair influence of big money in electoral process, require disclosure of all campaign money raised and spent, and hold elected officials and wealthy special interests accountable to the people, and also to create a level playing field for fair competition and ensure everyone plays by the same common sense rules. I had the opportunity more than 23 years ago to speak to the Prime Minister of Dominica, now Prime Minister of Dominica, at the time newly elected representative for the Vacas constituency, on national television about this very important matter of campaign finance reform. I asked him whether the time had come for us to consider campaign finance reform. His response was, quote, "Certainly, let us try to level the playing field so that everybody can have a fair chance to make a contribution to the country. There should be some kind of reform as to how we raise money for the campaign and how money is allocated. That would help tremendously in leveling the playing field," end of quote. The Prime Minister now says, and to be fair, he did reference it in that conversation back then, this question of state financing for political parties involved in election campaigns. But it has gone out now as what campaign finance regulation means. It means, from what we're hearing at some of these consultations, that political parties like UWP want money from the Treasury to campaign. I repeat, we have not proposed public funding for election campaign of political parties or individual members, in independent candidates, and nor have we proposed, nor do we see in the legislation proposed by Sir Dennis Byron any provision for public funding of the election campaigns of political parties. But let's be clear, the current administration, the current regime, is benefiting from public funding of its election campaign. It wants to excite the passions of Dominicans against public money being used for election campaigns officially, but privately, unofficially, it is using passport money through agents, etc., for its election campaigns, and it is also abusing incumbency in the seat of government to finance election campaigns. 2019, election year 2019, the overdraft of central government in that election year 2019 reached $187 million. $151 million above the limit approved by the Parliament. $151 million above the limit in the election year of 2019. $125 million of that $151 million was subsequently converted to a long-term loan at the National Bank of Dominica, meaning for 30 years, the people of Dominica will have to pay a loan derived from overspending by the sitting administration in the election year of 2019. Again, campaign finance reform does not necessarily mean the Treasury is going to finance political parties or that anybody is asking for the Treasury to finance political parties. That is something that came from Roosevelt Skerrit in more recent times, and something I notice has been picked up by the Labour Party operatives around Dominica participating in these consultations. In terms of the consultations, where are we? I hope that these consultations mean that the government understands they need to get it right with what is right for the people as opposed to what is right for any particular political party or candidate or special interest. We are where we are today because some years ago, the head of the Labour Party accepted advice that frustrated the implementation of electoral reforms in Dominica. This email needs to be read again. It needs to be read over and over again until everybody can recite it by heart, because it is where this problem that we have with electoral reform began. From Anthony Astafan, date Thursday, March 27, 2008, 10:27 in the morning, subject urgent, to Roosevelt Skerrit, copied to Alec Lawrence, lawyer, Hartley Henry, political advisor to the Prime Minister. Brother, please do not drift too far. Tried calling you again today and just cannot get through. I spoke to Kondwani this morning. There is madness going on at the commission. You need to call in Richard Charles and Kondwani Williams. I leave today. These guys are talking about reforms to include ID cards and complete re-registration. Such reforms will undermine your re-election legacy, as the opposition will say, look, the commission agreed with us, reform was required because of widespread fraud. Richard Charles and Kondwani Williams were the nominees of the Dominica Labour Party on the Independent Electoral Commission at the time. And what was of concern to the attorney advising the government is that reforms, ID cards, and complete re-registration of voters to clean the list of voters would undermine his re-election legacy. 15 years and 5 months have gone by since that advice. And we have seen no electoral reform. Obviously, the advice was accepted. And then the reforms that were promised by the Independent Electoral Commission in 2008 never materialized in the 2009, 2014, or the 2019 elections, notwithstanding widespread protest and solution-oriented civil society intervention seeking to make the electoral process fit for the purpose of honoring and protecting the people's right to free and fair elections. This regime's attempt to revise the electoral laws a few years ago was set aside by public protest because it was intended not to reform but to deform the electoral process further by legitimizing electoral offenses like bribery and cheating, which had been engaged to influence election results since 2005. The Organization of American States is one of the organizations that has observed general elections in Dominica, and they have done that since 2009. They reported in 2022 that they have made a number of recommendations on key issues related to Dominica's electoral framework and process. And the OAS says there has been little to no progress, either legislatively or administratively, on any of the more than 50 recommendations presented to Dominica since 2009. I note that the OAS is here observing these consultations. The CARICOM is here as well, and the Commonwealth is here. The OECS is here. There was a special joint mission of the election experts from those bodies invited by the government to present proposals for reforms to be implemented before the 2019 election. The special joint mission presented reform proposals as requested. They were immediately rejected. That election of 2019 was not free, it was not fair. With another 5-year term under his belt, Roosevelt Skerritt decided electoral reform would now be placed on the agenda of Dominica. I don't know how we got into the position in this democracy where for 15 years and more, we seem to be begging one man for reforms to the country's electoral process. So then we have the Sir Dennis Byron consultancy on electoral reform. Sir Dennis Byron was described to the people of Dominica as a neutral third party of high repute, former president of the Caribbean Court of Justice. He was engaged to review existing legislation, reports from the various chief election officers, election observers, and experts, conduct and review results of public consultations and advise on changes to improve the electoral process. He was to review and advise on the provisions for eligibility to vote, including the use of identification cards for the purpose of voting. And he was required to provide a report that advises on the way forward, including but not limited to any recommended legislative reforms to achieve the electoral reform objectives. So Dennis Byron accepted the 4-month assignment, September 1st, 2020 to December 31st, 2020, and he concluded it on June 12th, 2023, 2 years and 10 months later. The people of Dominica had a reasonable expectation that the legal luminary and international jurist would be independent, objective, fair, and he would exemplify the highest levels of honest professional conduct and impartial procedure in the discharge of his electoral reform responsibilities. Now, among the election observer mission reports that Sir Dennis Byron was obligated to see is the Commonwealth Observer Report of 2014, which concluded that the general election in Dominica was free, but was, quote, not necessarily fair due to multiple instances of cheating and bribery, including the transportation of electors to the island to vote, and the apparent abuses of incumbency, including a lack of impartiality in the provision of public services. Bribery, cheating, abuse of incumbency, taints on the electoral process. Three key pillars in the foundation of this regime's formula for securing election results in its favor. Sir Dennis Byron was aware of the concerns expressed by the Caribbean Court of Justice, our apex court, about the tainted electoral process in Dominica. In the draft of his Phase 1 report, the importance of these electoral reforms was emphasized by the Caribbean Court of Justice when it commented, and Sir Dennis includes this comment in his draft. Quote, there remain grave areas of concern about how the process of these 2019 elections were conducted. Future elections in Dominica ought not to proceed with these or similar taints, end of quote. Roosevelt Skerry did not like that reference, so in his final Phase 1 report, Sir Dennis switched to another reference more acceptable to Roosevelt Skerry. Following a snap election, a snap no reform election on December 22nd, 2022, the Organization of American States stated, and I quote, it is clear that Dominica cannot proceed to another election under the current rules. It will therefore be essential to have a new electoral framework in place before the next poll. The rules that the OAS referred to are the same ones that the CCJ told us in July of 2022 were tainted. And therefore we got to a situation in Dominica where this business about tainted election and a flawed process was no longer about politics and United Workers' Party saying this or some other party saying that. Independent observers and persons who had seen for themselves what was happening warned us and admonished us, we need to get this right. And the CCJ also reminded us, and I quote here again, without such free and fair elections, the preambular value of the creation and maintenance of and respect for lawfully constituted authority will be fatally undermined. The consequences of such a denial, that a reflection of Caribbean history demonstrates, includes loss of legitimacy, public unrest, and even revolt. In contemporary terms, free and fair elections are so fundamental to the democratic way of life that without it, the very legitimacy and sovereignty of the constitutional state is brought into question, constituted as is by the people of Dominica. In this regard, it is worth reminding ourselves the will of the people shall be the basis of the authority, the legitimacy of government. Now, in the matters, end of quote, in the matters that came before the CCJ in respect of the elections of 2014 and 2019, the taints on the electoral process in Dominica were clearly pleaded. And having read the CCJ judgment of July 2022, the consultant was well aware of the taints to the electoral process, the improper election practices that attracted the concern and the admonition of the apex court. Yet, in his transmittal letter accompanying the report and the recommendations, the consultant reveals, in my view, a state of mind in which the exercise was conducted that allowed him to brush aside taints of the electoral process as party political issues. I quote, I recognize that you were concerned, you meaning Roosevelt Skerry, were concerned about the implication that your government had engaged in improper election practices. I observed that you have categorically and consistently denied all malfeasance allegations and attributed them to the harsh political environment. I wish to assure you, I, Sir Dennis Byron, wish to assure you, Roosevelt Skerritt, from the outset I acted on the basis that my mandate did not encompass passing judgment on these matters. I deliberately refrained from seeking evidence on these issues. Throughout the process, I consciously steered clear of party political issues and proceeded on the premise of service to the national interest. So Dennis went on in the transmittal letter to confess to Mr. Skerritt, the quote, ultimately, I concur with your assessment that there were few fundamental points on which your government policies were inconsistent with the other voices engaged in the deliberations. I listened to and considered the views expressed carefully. The content of my report varies from some of these views. Indeed, end of quote. Indeed, in the matter of views on voter ID cards versus national ID cards, biometric data, fingerprints, disqualification of voters residing overseas, and in every other area of contention arising out of Mr. Skerritt's need for an electoral process that can be manipulated to protect his re-election legacy, the consultant came up with recommendations to support the Skerritt agenda. Number one, he proposed an act providing for the issuance and management by the Electoral Commission of a national ID card to persons outside of the electoral system for purposes which are unrelated to voting and elections, which is inconsistent with responsibilities conferred on the Electoral Commission by the Constitution or supreme law. What the Constitution provides at Section 38(1) is that the Electoral Commission shall be responsible for the registration of voters for the purpose of electing representatives and for the conduct of election of representatives and senators, and shall have such powers and other functions relating to such registration and elections as may be prescribed by law. End of quote. In the draft Phase 1 report of Sir Dennis Byron, November 2022, he deals with the importance of voter identification cards in the electoral reform process. Quote, the introduction of voter identification cards to persons registered as electors supported with biometric data was considered one of the most important reforms by almost everyone. It was regarded as essential to eliminate or minimize a wide variety of fraudulent conduct at elections, including impersonation and multiple voting. The issue of these voter ID cards has been mandated by Clause 11 of the Registration of Electors Bill. End of quote. In his final Phase 1 report, Sir Dennis Byron made a dramatic shift to national identification cards, claiming he had a commitment to follow government policy, notwithstanding his concerns that elements of such a policy could be inconsistent with the Constitution or supreme law. And he says, in his report, the Registration of Electors Amendment Bill 2019, which was tabled in Parliament but not passed, had proposed a national identification card. Inasmuch as the 2019 bill reflects government policy, the legislation I have proposed reflects in the main the provisions of that bill relating to a national ID card. However, I would be remiss if I did not highlight the following concerns. And among the 4 concerns, Sir Dennis says, quote, a question arises whether the issue of a card for the purposes unrelated to the registration of voters and electors would be consistent with the constitutional remit of the Electoral Commission. The question is whether the promulgation of an act which provides for the issuance and management of the Electoral Commission by the Electoral Commission of a national ID card to persons outside of the electoral system and for purposes which are in the main unrelated to voting and elections would be consistent with this provision of the Constitution. This needs to be explored, end of quote. His Phase 1 report goes into great detail about using biometric data technology in the voter identification process, but it is not included, it is not reflected in the actual revised legislation he has proposed to give effect to the electoral reform recommendations. The proposed legislation, the Registration of Electors Bill 2023, contains no specific provision for the inclusion of biometric data on identification cards for voting. The security features on the card, whatever those may be, will be at the discretion of the Chief Registering Officer, and there is no requirement in the proposed law or in the regulations to the proposed law for photographs, fingerprints, ID number, voter registration number, polling district, voter name and address to be included on the ID card for voting.
Just 1 minute, Mr. Linton. I would like to recommend that we wrap up. We do have a number of others who are here who would like to contribute to this discussion. So we also would have another session in Marigot next week on Tuesday, but just for the benefit of all who are here, we would like to ensure that we can wrap up.
That
So
being
we
the
have a
case,
few more
Madam
speakers
Chair, I
to
will
speak.
leave it here, and we can pick up. If we get to Marigot, then we can talk some more. Thank you.
Thank you. Thank you very much. I just want to reiterate, thank you very much, Mr. Linton, for your contribution. I would just like to reiterate that we are here, yes, for consultation to hear your views, but there are a number of us who are here, so I would advise that for future speakers, that we try to keep our contributions as reasonable as we can, so that we can all hear multiple views, that we can hear from you who are here in the Northeast today. I believe the Attorney General wanted to make a few comments.
Yeah, Madam Chair, it's unfortunate that the session took the turn that it did, but it would be remiss of me to sit here and not make some kind of response. I'm not going to go into detail because I don't think this is the proper forum, and I don't want to usurp the time that other people want to make contributions. But a whole series of claims and allegations have been made, totally political, which is fair enough, but this is probably not the forum. And what's more is that a number of them are totally inaccurate. I, as Attorney General, and someone who from at least 2015 has been involved in attempts to draft legislation. In fact, we drafted legislation. We went to the House of Assembly with the legislation in 2017. So to sit here and hear somebody come and say that the government has done nothing, I'm sorry, I can't entertain that. In addition, I have a recording on this, which I was going to play, of the person who just spoke, saying that the draft legislation was fit for purpose. I'm not going to play it to allow other people to proceed, but I will play it at another forum, where he said on Q95 FM on the 30th of August 2018 to Richie Farrell on the news that the draft that the government had gone away and prepared was good and it was fit and would work for the purpose of achieving the objective that we are seeking for electoral reform. So I can't sit here and not respond.
Thank you very much, AG. Just to recap, at the beginning, I think the AG made a few points in terms of the summary of the report. Some of the areas that we would like to hear your views on. Earlier on, we indicated national ID card, voter ID card, registration and confirmation of voters, political campaign financing, and a number of other areas. So I believe we had a few more hands up. Mr. Roll, yes? Can you stand? Would you like the mic to come to you?
Thank you very much, Madam Chair. Good evening, ladies and gentlemen, persons at the head table, the Honorable Attorney General, former Prime Minister of Dominica, Honorable James. It has been years now we've been hearing about electoral reform and championing the cause for and of electoral reform. I want to deal with just 3 items here: ID cards for voting. Brothers and sisters, I have an envelope in my hand with a few documents therein. A passport. This is my passport, and the state provides a passport for Dominicans to travel. I have here a card as a farmer so that I can sell my produce as a farmer, identifying myself as a farmer. I have another card, a driver's license, identifying myself as a driver of a vehicle. I have a social security card, identifying myself as somebody associated with the Dominica Social Security. Why then can we be talking about electoral reform and refuse to associate ourselves with an ID card specifically for voting? Not a national ID card, brothers and sisters. We believe, a national ID card involves every Dominican. There is too much room for fraud and corruption. St. Lucia have ID cards specifically for voting. Antigua has ID cards specifically for voting. Jamaica has ID cards specifically for voting. I humbly suggest to the persons involved in drafting the laws of the Commonwealth of Dominica in respect to electoral reform that we in Dominica deserves an ID card specifically for voting, a voter ID card. Thank you. Number 2, outside of Dominica, 5 years and more. I believe it is unreasonable for individuals who lives in the diaspora, who enjoy all sorts of perks, sweetheart pension plans, wages. I am associated with the construction sector. If you attempt to make $250, $300 a day, you might take jail for somebody's project. I have friends working in the United States for $35 an hour, $55 an hour. Why should they live in the United States, live in Great Britain, come down here on a holiday, or come down here with a ticket being paid by a political organization to keep me under the rules and regulations of a political party that has failed me, that has failed us? I believe if you live outside of Dominica for more than 5 years, you have seen greener pastures elsewhere. So you should allow us to choose the representatives we identify that can deliver for us in the Parliament of the Commonwealth of Dominica. Brothers and sisters, I want to talk about the whole question of re-registration or confirmation. I personally believe, I am convinced that the only way to ensure a clean voters list is the re-registration of voters in Dominica. However, if there are those among us who believe that the cleansing of the list can be also achieved by confirmation of voters, brothers and sisters, let us do it within the boundaries of the Commonwealth of Dominica. How can we suggest, brothers and sisters, how can we suggest that we will identify 4 or 5 countries around the world for our brothers and sisters in the United States and England to go and register? What about the other countries? There are over 200, 300 countries. You can correct me, for former foreign minister, if I'm wrong. We have to try to level the playing field. We cannot say, let us go to New York. I have 3 sisters in New York. But what about London? What about Brussels? Paris? We cannot say 4 countries or 6. No. We have to say all of them. And who is going to finance it? The most decent thing to do, in my humble opinion, brothers and sisters, is to have all of the work done within the boundaries of Dominica. And finally, brothers and sisters, the question of access to the media. Brothers and sisters, it has been painful over the years to see a political organization in government uses a private entity, a private media, to sell its message and literally closes out the opposition from access to state-owned media. If we talk about equal time, the ruling party has mastered a technique of not going on the state-owned media and using private media. So they will come and say, well, we wasn't on DBS or we wasn't on this. Let us be reasonable and honest. Let us do it not for party, but for country. Let us state, like in Antigua, every media organization, whether private or public, should give full access to medias. That is my thoughts. Thank you very much, brothers and sisters, members at the head table, for your time.
Thank you. Thank you very much. I believe we had a hand on this side. I'm not seeing, it's a bit dark on the outside. Hold on. There was someone here who wanted to speak? Okay, Mr. James?
Thank you very much, Madam Chair. It's okay? Yes. But me hear the chairman ask nobody no attack? Nobody else no want attack? No, man. You can't let them people come here and know how we talk. Madam Chair, I'm going to say protocol having been established. I'll move on. I just want to make clear that I gather that there might have been a problem with GIS, so that when Mr. Linton started to speak, he got muted. I don't know whether that is true, but I just want to say that there might be a problem there. So I hope I can speak without being muted. There's no way we can talk about meaningfully about electoral reform without paying some attention to the background. But Mr. Linton has gone somewhere in that regard. When I spoke at the State House, I did reference this famous or notorious email from Anthony Estefan. And it is of deep concern, it has to be, that the Constitution of our country gives the responsibility and the authority for electoral matters, registration and the conduct of elections, to